Yeah, we'll do share screen. All right, well, good afternoon, everyone. My name is Leola Carter, and I am your host for today's webinar. I am a SCORE mentor in the Minnesota division, where we have over 90 volunteers serving both Manatee and Sarasota counties. I am also on the education committee, and we are excited to bring to you today's presentation on W-2s versus 1099s. I have been an entrepreneur myself for over 26 years, so definitely interested in seeing what I'm going to learn today. And an example of one contractor that I 1099 is my snowplow guy. So let's see if I am doing that correctly. But before that, just a little bit more about us here at SCORE. We are a nationwide nonprofit organization that is an independent part of the Small Business Administration. What can SCORE do for you? We provide free mentoring services and educational services such as this webinar. We can help you in all stages of your business process, from your first initial thought all the way right up through where it is time to sell. And to find us, you can visit our website at score.org/Minnesota, where you can find all of these services. Today would not be possible if it weren't for our sponsors and community partners that we have listed here. And today we have SCORE's very own Barry Portugal and Denny Schlepper, who are here to talk about the challenges for business owners and independent contractors in relation to W-2s versus 1099s. And then Denny, I am going to stop sharing my slides, and you may go ahead and begin and share your screen.
Well, thank you, Leola. I really appreciate the work that you do on the education committee for our chapter. I know it's a lot of effort, and thank you for coordinating all of this. And welcome to everyone, either good morning or good afternoon, depending on where you're located in the country. If you look at this presentation today, I would imagine what we have on the call are probably two groups of people, maybe more, but at least two groups of people. Some of you on the line are employers. You own a business, and you in one way or another have workers that you currently use in one fashion or another. The other group of people that are on the line are more than likely what we would refer to as the workers, maybe the independent contractors themselves. When Barry and I put this presentation together, we tried to address both groups of people because you will have different perspectives on this issue. But before we get into the issue itself, maybe we'll just jump to a disclaimer to help you understand a little bit more as to what SCORE's purpose really is. SCORE's purpose is to bring these types of issues to your attention. Our role is not to necessarily advise you on a specific issue, or in this case, advise you on, do you have an employee relationship or do you have an independent contractor relationship? It's more so to maybe help you ask the right questions.
And Denny, can I interrupt you for just 1 second?
Sure.
I have a thumbnail view of your screen. If down in the bottom right corner, there's a little slide bar, and then there's a thing that maybe looks like a projector. And if you click on that, it will make the whole screen just the disclaimer. Do you see? Well, that definitely made it bigger. So right next to that, just to the left of that, that little, yes, that right there. There we go. It looks perfect. Thank you.
So again, our SCORE's role is really to help you ask the right questions, bring the information to you. Many times you will have to go to either your legal, accounting, advisory professionals to help you decide on some specific issues. So as we get into the questions and answer portion of this presentation, We probably won't be able to answer a specific question on do you have an employer relationship, employee relationship, or an independent contractor relationship. But once again, hopefully help you ask the right questions and see if your situation is even applicable. The other purpose of SCORE is to make sure that we bring you the right information. And so what Barry has done is that you'll see at the bottom of many of the screens, many of the slides, there's resource material for you that you can refer to and click on once you receive the presentation, as Leola mentioned. And that'll definitely help you answer some of the questions that you might have. So with that, looking at the agenda today, we're going to jump into why is this even an issue? Why the new rule itself? There's some interesting information around that. We're going to have some definitions so that we know what we're all talking about when we're talking about an employee, an employer, an independent contractor, a subcontractor, and so forth. We'll put some definitions around that, hopefully to help with the clarity. We're obviously going to look at this regulation at a very high level. We're going to compare it to what we would call the old rule versus the new rule now. And then Barry is going to very much dive into the updated rule for us so we can get into the specifics of that rule. And once, of course, we're done with those specifics and we maybe have a good understanding of the details, we're going to try to bring that back to kind of what we describe a more practical view. What does that really mean for you, either as a small business owner, a large business owner, or as an independent contractor, or if we happen to have subcontractors on the line, and help you maybe understand what are some of the positives of this, what are some of the concerns. And then we'll finish up with the next steps, the links to those resources, and of course, the overall agenda. So let's look at the new rule. It comes from the Department of Labor. So let's understand that this is a federal rule. All states, and I saw that some of you represent different states, all states are governed and have labor laws, but all the states also are subject to the Department of Labor from a federal perspective. Now, one of the things, if you look at the why is this in place? I'm going to get the political view out of the way first. If you were to jump and look at a lot of articles and a lot of things that have been out there in the last 2, 3, 4 months, you would find articles, this is in SCORE's opinion, you would just find articles that would indicate that there's a political angle here. What you will find is that as we go through this presentation, it's very likely that in the future, there will be more people classified as employees versus independent contractors. The political view is that perhaps this is done so that we increase the number of employment figures that are out there, which would obviously, from a political standpoint, you could argue would help a political campaign if you have the employee numbers increasing within any given period of time. That's the political angle of this. If you look at what the Department of Labor indicates, it's to help us be consistent as we go forward. In my past lives, I think I would agree there has been a lot of inconsistency throughout the country, throughout employers, throughout independent contractors. What is that working relationship? What should it be? What is it legally? And then are we all following the same rules and playing on the same field? I think it's a fair argument to say that really has not happened in the past. So there is a legitimate argument that there's a consistency factor here, not only consistent so that we're all operating the same way, but that case law is consistent with that as well. Department of Labor will also indicate that perhaps they're to protect the employees, which would be true as well. So they use the term workers. So now let's get into these definitions of worker. What are workers? So for this presentation, Barry and I decided, let's make it clear that when we refer to employees, we are clearly referring to individuals that are paid by W-2s. They are legally employed by a business. I think we all understand that. Probably all of us on this call have been an employee at some time in our lives. So we understand that. We're subject to federal and state labor laws from an employer perspective. We're protected by those federal and state labor laws from an employee perspective. From a tax standpoint, we pay half of the FICA, 6.2%, and we pay half of the Social Security taxes, the 1.45%. The employer pays the other half of that. And I'm going to just pause here for a second and indicate that some people will say, well, the why behind this change in the law is to collect more taxes. It's a tax raising strategy. Now, you could argue that, but I think practically or technically, there's probably not an argument for that. In other words, if you have an independent contractor, in theory, the independent contractor is paying tax on their income, and they're paying what we all know to be self-employment tax. But they're paying the entire, as you see under the definition of independent contractor, they're paying the entire 15.3%. So it isn't necessarily that more tax would be paid under these changes in the labor laws. It would be who's paying those taxes would be the difference. So again, employee, I think we can probably understand that definition pretty easily. Independent contractor, an individual. So this individual, Leola mentioned her person's doing the snow plowing, probably is an individual doing it on an individual basis. There's 1099 reporting that's required. So instead of issuing W-2s to an independent contractor, a 1099 is issued to those independent contractors. And of course, the working relationship is subject to the contractual arrangement between those two parties, the employer and the independent contractor. Now, sometimes that contract is even verbal. It's not necessarily written, but there's still a contractual arrangement. And then let's define subcontractors as something a little bit different here. This would be an incorporated entity. So let's say, in Leola's example, that her snow plowing company is actually a company. It's not an individual doing the work, but she hired an entity to do that work. Well, she's still required, if she meets the certain standards as far as the minimums of dollars paid to them, they still receive a 1099 as an entity, as an incorporated entity. It could be an LLC, it could be a C Corp, but they still receive the 1099 reporting. Once again, it's subject to the contractual arrangement between the employer and the subcontractor. And the taxes are then going to be subject to whatever the incorporated status is of the subcontractor. So Barry and I are going to be very careful. When we say independent contractor, we're referring to the individual. If we use the term subcontractor, that's an incorporated entity. So let's take a look at this law under those definitions at a glance here. It was effective March 11th, just a few days ago. I felt that over the last 2 or 3 months prior to March 11th, this was receiving some publicity, but I would not say a lot. I think a lot of people were somewhat taken back. I know when SCORE started getting this information out to all of the SCORE clients, I didn't find too many people that were aware of this law. So for all of you on this webinar, I think you're probably in some cases on the cutting edge of it, even though it's already effective as of March 11th. And I think it's become clear it's addressing the classification of, do you have an independent contractor relationship or do you have an employee relationship, and how to analyze that, and also the changes that have taken place. One of the changes, and you're going to see this a little bit throughout the information, is you're analyzing what they indicate are the circumstances under the economic reality test. Barry's going to get more into that, but it's a change from where we were previously at. So let's look at the difference between where we were and where we are now under the old and the new law. The old law had many factors here defined as core factors that would help you determine, are you an employee? Are you an independent contractor? As an employer, do I have an employee or do I have legally an independent contractor? And out of many of those tests, the issue was if you met a few of them, enough of them, so that you could argue this is clearly an independent contractor relationship, you were pretty much good to go. You had an independent contractor relationship as long as you could argue that there's enough factors that are in play for you if you wanted that independent contractor relationship. But it's what we would define, it was very business friendly, meaning if the business wanted to have an independent contractor relationship, the core factors were favorable for that business in order to comply and to be legally in compliance with an independent contractor relationship. The new law has 6 factors, not a multitude of them, but just 6 factors, back to this economic reality test. And Barry's going to again once dive into this further, but instead of just looking and saying, well, I have 2 or 3 or 4 factors that would argue this is an employee or this is an independent contractor, and therefore I can rely on this. Under the new law, you have to look at all 6 factors in their totality and try to indicate, when you look at all of those factors, do all of them lean more towards an employee relationship or more towards an independent contractor relationship? And you can see that there's a broad statement indicated here that if a worker or if an independent contractor is economically dependent on the employer for the work that that employer is giving, then that whole economic reality test is probably going to lean towards an employee. And so as Barry is going to dive into these 6 factors and get us deep into it, the overall premise will be independent contractors that have been in the marketplace in the past. As of March 11th, there's going to be a strong argument that perhaps they're no longer independent contractors and they really are employees. So with that, Barry, I'm going to turn it over to you to dive into these 6 factors known as the economic reality test.
Thanks, Denny. Welcome, everybody. I'd like to start by following up on what Denny just said. In reading the regulations, it's very clear that the totality of the circumstances are really the key factor. They say that no single factor alone is going to be determinative of whether you're an employee or an independent contractor. The key that I'm taking away, and I'll bring this through the explanation here, is that if you have a business and you are incorporated and you can demonstrate an entrepreneurial approach to your business where you are serving more than one client, there is a tendency in the regulations, which I'll explain in a minute, that may suggest that you're an independent contractor and not an employee. But the 6 factors that are listed here, I'm going to go through one by one and again talk to you about what it may mean for your own business or for yourself. Let's start with profit and loss. Basically, one of the factors says is that if you have an opportunity to generate profit or loss or are managing an aspect of the business, the chances are that you will be identified as an employee. What does that mean? Do you meaningfully negotiate for work? Do you accept or decline jobs? Do you engage in marketing? Do you decide who to hire? If you are not involved in those aspects, then the worker would be classified as an employee. But the key here is the entrepreneurial nature of profit and loss. So a typical worker is not declining jobs that their bosses say, would you please do this? And they do it. The employee does not engage in marketing, and the employee certainly does not decide who to hire. So that's where, as long as they don't meet those tests, then the individual would be an employee and not a contractor. The second element is whether or not there's investment by the employer in the capital tools, equipment. So if the employer says you must buy this equipment in order to work for us, that suggests that the worker is an employee. However, if the investments are capital entrepreneurial in nature, meaning that you're a snowplow driver and you have different snowplows that you use, that would lend toward being an independent contractor. The key here is that the investments that are entrepreneurial in nature often indicate an independent contractor status. So as you're thinking about what you do, and as an employer, you think about who you're hiring and how to classify them, is that if they are have their own tools, their own capital, they're involved in developing their own business and working independently, that suggests that the worker would be classified again as an independent contractor. Now, as Denny said, for those of you that want to know more about this, the links at the bottom of the pages will take you to the FAQs that we took some of this information from. But we'll be saying this throughout the session this morning. The best way for an employer or an independent contractor to really understand these regulations is to talk with your accountant. Your accountant is the best source of information. And what we're doing this morning is essentially giving you the highlights of these issues. But by depending on your accountant for advice, you'll be in a much more secure position. Another factor in whether you're an employee or an independent contractor is what they call the degree of permanence. So what does that mean? It means that if you have a job and you just go into work every day and there's no end point, you're just working there and on a continual basis, that worker is considered an employee. However, if the work relationship is defined by a certain period of time in duration, I have a project here I'd like to have you do. I'm a consultant. I'm a college professor who comes in and teaches a class. There's a specific beginning and ending point to it. Or indeed, if it's sporadic in nature, the Department of Labor regulations state that kind of worker would be classified as an independent contractor. What the regulations also say is that if there is no permanence involved, the independent contractor status is that where the worker is deciding what they want to do on their own. No employer is telling them how long they have to work. So to summarize, if you have a position as an employee and you go to work every day and there's no endpoint to your working, that would classify you as an employee. One of the other important factors, and this one comes from one of the former regulations that was relied on a regular basis, is the employer control over the worker. What the regulations say is that the worker can be classified as an employee when the employer sets the worker's schedule, supervises the performance of the work, limits the ability of the worker to work for others. So as an independent contractor, you will have several or more clients, whereas an employee, the employer says, you can only work for me. Additionally, the employer says, I reserve the right to supervise or discipline you, or they place demands or restrictions on your work that categorizes you as an employee. The key here for control is that the more control a potential employer favors at being an employee, the more control that the worker takes under their responsibility favors them as an independent contractor. So this is just one of, again, several of these factors that has to be considered. Another factor that many businesses find confusing, and understandably so, is that the DOL regulations say that the work has to be integral to an employer's business. The rule says, what is the extent the work is performed to be integral? Here's what they say. Integral is defined as the work that's performed as critical, necessary, or central to the potential employer's principal business. So Leola's snowplower is providing a sporadic business, but it's not central to her business, and that would suggest that that individual would not be an employee. Another factor for integral, if the work performed is central and a whole part of it, that the business could not operate without that, then the regulations suggest that that worker would be an employee. So when the work is performed but is not critical, not necessary, or not central to the employer's business, that worker would be classified as an independent contractor. However, if we step back for a moment and think about this particular factor, I think we would all agree that this is vague. It can be interpreted in so many different ways. And my sense is that this will be one of those issues that's going to require more definition down the road. The other factor is skill and initiative. So if the worker doesn't use what the DOL calls specialized skills to perform the work, or where the worker is dependent on training from the employer, that would categorize them as an employee. However, if the worker brings specialized skills to a work relationship, that doesn't necessarily mean that they're an independent contractor, because both employees and independent contractors may have skilled workers. For example, if I'm a plumber, or I'm an electrician, or I'm a carpenter working for a contractor, I bring those special skills to the place of where I'm working, but I can, under one circumstance, be considered an employee, and in another circumstance, be considered an independent contractor. It's the worker's use of the skills in what they call business-like initiative that allows the worker to be classified as an independent contractor. The key here is business-like initiatives. As we go through this rest of the presentation, we talk about the entrepreneurial nature. We're going to be talking in a minute about the incorporated status of the individual. These are all going to be factors that will determine which side of the coin the employer will consider to be the worker. Now, in addition to those factors, this is a really important one. According to the regulations, they say that if the worker is in a business for themselves, as opposed to being economically dependent on the potential employer, that would lead them toward an independent contractor status. Again, if they're in business for themselves, and when we go back in a minute and talk about the different categories of worker, if you are a worker that has an LLC or some form of corporation, and you are economically dependent on more than one client, that would suggest that they would be an independent contractor. One of the questions that we were asked earlier is, does a worker have to satisfy all of these factors to qualify? And according to the regulations, it says no. No single factor automatically determines a worker's status as either an employee or an independent contractor. And the bottom bullet here, I think, is really important. All of the factors are weighed to consider it, and how it's considered, and how the employer characterizes their worker is going to be a factor. Again, it's the totality of the circumstances that will drive the question. We were also asked a question about tax-exempt organizations, and I'm not going to read the slide except to say that if you are a tax-exempt organization, you are eligible, you are covered by the regulation and need to follow the same factors that we've discussed before. The link at the bottom of this page is from the Council of Nonprofits. I suggest that if you are a nonprofit, you may want to read that link. We do have people from different states on the call, and just to point this out, that the states don't have to modify their regulations because they all have them. Fair Labor Standards Act, each state has their own, but the federal regulations regarding the totality of circumstances is going to give the overriding responsibility for deciding whether a worker is an employee or not. So it's not the state regulations, it's the federal regulations. Now, before we turn this over to Denny for some other comments, because we are not lawyers nor accountants, what I wanted to do, though, is to share with you information that I received through the American Bar Association. And what I found is that they had a list of mistakes that are often committed by companies that classify independent contractors, but oops, turn out to be reclassified as employees. So here's the list. You can read through all of them, and you need to ask yourself the question. What elements here do you as an employer require from a worker? Do you reimburse their expenses? Do you spend a lot of time supervising them, setting the hours, prohibiting competition? These are all factors that the Bar Association pointed out to be ones that were used to reclassify an independent contractor to an employee. So I would suggest that if you are interested in these, please refer to the link at the bottom of the page. And with this, I'll turn this back to Denny for further comments about these issues. Denny?
Thank you, Barry. This is the part of the agenda where we kind of step back from the details of the law and just try to answer, what does this mean to us, depending on your specific situation, what's happening in the country related to this new law. And as you see here, there's no doubt that the general feeling is that we're tilting the playing field to be more employee orientated versus, as I mentioned earlier, kind of the business friendly approach from the previous law. If you look at the totality of the circumstances, in many, many more cases, we're going to end up looking at this as an employee relationship with the employer and not an independent contractor. You also have to look and say, well, what does this mean in the country as to the gig community? We all know what that is. How is this going to impact them? You can go very, very large. I doubt that they're on this call, but look at Uber. Look at maybe some very large employment worker relationships that are out there that could get impacted by this. This is not a small change. We actually feel this could be very, very large. Also into the future, there may be modifications that are made by the Department of Labor on this because of perhaps pushback or confusion. In fact, I'd be surprised if we don't see further regulation around this in the future. But as of today, March 11th, this is the law. And it is something that all employees, employers, independent contractors, and so forth need to follow. And because it's tilting this field, we're looking at greater liability risk for businesses. It just simply is there. You can't find a law firm publishing anything on this that doesn't address the additional risk that businesses have, the employers. The risk, of course, being that they are classifying their workers as independent contractors, but they're clearly or very clearly employee relationships. And when you have that, then you have to ask the question, what is the risk? Where does this risk come from? Well, let's understand that it is the Department of Labor. It's not the IRS. It's not the state taxing authorities that necessarily are going to come into your business and say, you're misclassifying these workers. The more practical way that this becomes a risk to you is, one, you either participate in a very large employer work relationship. I gave the Uber example, but where somebody's going to look at it as a very large class action suit scenario. Okay, most of us on this call, probably that's not the scenario that we are in. So where is your risk? One of the most likely areas that businesses will have this risk is you're going to get turned.
Oh, Denny?
That they should have the employee rights that you have not given them. And therefore, they turn you in to the Department of Labor or the state authorities. And therefore, at that point, you start to get targeted. That's where a potential risk is. The other area is if another department, let's take, for instance, for those of you that are in the state of Florida, and let's say I'm going to take an example of a hair salon or a massage therapist company where you're renting out space to an independent contractor. Well, in the state of Florida, different than many states, but in the state of Florida, that requires sales tax on that rent that in effect is being paid for that space. Well, if the state comes in on that issue,
Denny? Leola?
Denny, you just froze up again. That's the second time. The first time it only lasted a second, but I believe you are still frozen. Yeah, Joanne, a couple people say that they can't hear you. Barry, do you want to step in if your Wi-Fi
Sure,
is?
I'll continue, and Denny, just come on back in when you can. The key that Denny's saying here on this particular slide is that there are lots of different ways, a lot of different businesses where if you are categorized as an independent contractor, but you think you should be categorized as an employee and have all of the insurance benefits, there is a large risk here. It's very important to consider in terms of what may happen. Let me move on to the next slide.
Okay, I'm just gonna, I think his timed out, so just bear with me for a second. I'm gonna try to get to the right one. If I flip through that, Barry, and I pass it, just let me know.
I'm sorry, what are you doing?
I'm gonna take over the slides for Denny, but
I'm the one controlling the slide.
Oh, okay, are you on there now?
I was until yes.
Oh, okay. I thought that was coming from Denny, and I was concerned since he jumped off. Okay, you might have to start screen sharing again. I apologize.
Well, now you've got the slides.
Yeah, I'll just change it over.
Bear with me. Bear with me here. Okay.
There we go. Thank you. Sorry about that.
Okay. Okay, this is what I apologize, folks. This is where we were. In addition to the risks that Denny was mentioning in the last slide, this is a more practical, down-to-earth impact that could be there. And that is if you're an employer and you have independent contractors and you are not paying their taxes, you could be liable for paying from 10 to 12% more in taxes and other expenses when hiring employees as opposed to contractors. Things are easier when you're paying a contractor because they're responsible for their own withholding. But if we think about examples of, say, a restaurant may have some individual workers who are classified as employees, but others who are classified as independent contractors and rely on tips that they get for their income. So there's a lot of potential risk here. And the message is to the employers, it's important that you meet with your accountants to go through this issue. We added this slide because it's important to talk about the fact that the definition of an incorporated subcontractor is if you have incorporated with a state and registered, and the arrangement you have with the company, you can demonstrate that. That would improve your position as an independent subcontractor. An independent contractor that are not incorporated are governed by the new law. That's really very important. So we'll be talking in a minute about how to consider whether or not you should incorporate or not.
Barry?
Are you there?
Yeah,
Yes,
I'm
Danny,
sorry, I lost
you.
my internet connection. So I apologize for that. And I know my camera's not working yet as I sign back in, Leola, but maybe you can work on that. So I apologize for that. I appreciate you jumping in. What I wanted to do was hit on this from an employer perspective as well, subcon or independent contractor perspective. If you look at maybe some of the positives of having employees, if you are an employer, some of those positives could be that you can demonstrate more control over that relationship as an employee. I think that's probably understood by most of us that that's possible under an employee situation. This is more of a personal feeling more than anything else, is that if you look at the culture of your organization, if you look at the culture and the team approach that you're trying to build within your company, I've been around a lot of small businesses, and I have a strong belief that you can do that more likely under an employee relationship that you have versus an independent contractor relationship. Now, that's not always the case, and I'm sure somebody could argue that different. But I think the majority of businesses that have an employee relationship, it's more likely to build that stronger culture and team approach. And the other thing that's probably something that I've observed is when you're looking to sell a business, all of you that own a business on the line, you're looking at an exit strategy at some point. Well, if that exit strategy is the sale of your business, the fact that you have employees versus an independent contractor business model could add more value to your sale. I'll give you an example. Company that I used to work for, we did a lot of outsourcing, accounting, finance outsourcing for businesses. And so I went around the country looking to purchase these outsourcing businesses to bring them on board. And one of the first questions I would ask is, are your workers independent contractors or are they employees? And if they were independent contractors, I would immediately indicate that I'm not interested. It's not the type of organization that I think created the value that I would be paying for. But under an employee relationship, I felt perhaps it was more likely that there was a value proposition there. Doesn't mean that's always the case. It's just what I found to be most often. Under the concerns, we mentioned it already, you have more cost as an employer with an employee status relationship. There's more employment regulations. You have to follow both the federal and state employment regulations under that. And it could be more difficult to grow and expand. What do I mean by that? Well, the whole gig community that I mentioned earlier, there's a desire to remain independent contractors. That's why they are already in that gig community. And for you to find the workers, which we all know is difficult to do, and then if you indicate to them, but we need to have an employee relationship, you may lose them. That's a concern. That's a risk. And I'm sure many of you already are probably thinking through that. And then, of course, potentially less flexibility with that relationship as an employee as well. So let's look at it from an independent contractor perspective. What could be some positives for the independent contractor under the employee status? More benefits than what you have as an independent contractor. You would have the regulation protection from an employee status, again, both federal and state. And then you have the ease in tax preparation because now you're issued a W-2. And obviously, you're only paying half of those employment taxes that we discussed earlier. But you simply report your W-2 on your individual tax return, which I'm sure we've all done at a time or two. Well, what would be the concerns? Well, there are tax disadvantages, perhaps. If you have an independent contractor, if you are an independent contractor, you have the ability on your Schedule C of your individual tax return to deduct expenses related to that income that you were paid on your 1099, and therefore reducing your overall self-employment income, which is all taxed, of course. And as long as those are legitimate, deductible business expenses, you have that ability to do so. You lose that under an employee relationship. That is a major concern for independent contractors. And again, because they like the independence, they don't like the regulations, they would see that as a negative to have more employment regulation and perhaps a sense that their independence has been reduced as well. Once again, just like an employer, they may see that as a potentially less flexibility. Now, one of the things I wanted to mention is we talked about subcontractors. And once again, that subcontractors defined as a legal entity has been formed would not be governed by this law. So one of the things that I believe independent contractors, again, these are individuals now, that independent contractors may do is they may actually incorporate
And
to say, I
we'll cover
understand.
that, we'll cover that in just a minute. But can we stay on the reduced sense of independence and
Sure.
lack of flexibility? For those people that are on the call who are not necessarily employers, but who are independent contractors or who think they are, one of the senses that I have from talking to other people is that the reason they chose to be independent contractors initially is they wanted to be on their own. They like the idea of having their own business. They want the flexibility of making their own decisions. And one of the concerns that I have about these regulations is that people who are in that position probably absolutely do not want to become an employee. I'm sure there are those that do. So it's something to be considered, and as we move forward, the individuals who are thinking about this need to give this a lot of thought about what they can do to protect their positions one way or the other. So here's some basic suggestions for the employers who are considering these regulations. Before you hire anybody, review the duties and the control. How much control will you have on them against the reality test to make sure they're in the correct classification? Now that you have all these factors, and remember, no one factor is going to determine a category. They're all going to be considered together. Think about the independent contractor status. And if you have individuals who are misclassified now, when you talk to your accountant, discuss whether or not you need to reclassify them under this new rule. If you have contracts with individuals who are defined as independent contractors, make sure that there's nothing in the contract, or there is something in the contract, depending on the way you look at it, that will clearly define their responsibilities so that they are they'll be able to be classified as independent contractors more thoroughly than not. And if you have policies and procedures in your handbook about categorizing employers, make sure that you update those categories. Now, Denny was talking about the incorporation. Denny, would you mind taking a couple of these bullets for me and explain what you had in mind?
Yes. The second bullet point specifically on forming a single member LLC, this is from the independent contractor's viewpoint. As we define independent contractors, we defined it as an individual. But if you have an independent contractor, if you are one and say, I do not want to be an employee, that's not the relationship that I want. One of the alternatives could be to say, I will form an LLC. And when I indicate a single member LLC, that means within your specific state, you register with the state and you form a legal entity. And within all states, if you were to select an LLC as your legal entity, it's known as a member. Instead of a stockholder, it would be called a member. how many members do you have that have ownership in that LLC? Well, if it's just you, the one individual, you only have one owner, they own 100% of the LLC, that's known as a single member LLC. Why is that important? It's because then there is no income tax return requirements for that LLC. You don't file a separate corporate tax return. You just simply file your income and your expenses back down to your Schedule C on your individual tax return, just like you did as an independent contractor. So you have the LLC legal protection, and you perhaps avoid this law being classified as an employee. Now, this may work for many situations, but it clearly doesn't work for all situations. Many independent contractors just won't have the sophistication or the desire to go through those steps of the LLC, filing corporate status every year, all those requirements. It might just be too cumbersome for them. So therefore, it could be an option in some cases, maybe not in others.
Right. The last bullet point, though, is also an issue for independent contractors to consider. If you're an independent contractor, you may want to try to expand the number of companies or clients that you have, so that it'll be easier for you to demonstrate the entrepreneurial nature of your business. If you have working basically for only one person, it'll be more difficult for you to characterize yourself as an independent contractor. The last slide is a list of all of the different sources that you can go to and read about. Again, our recommendation is that the best source for you to go to is your accountant, maybe even your company attorney, to make sure that you have all the information clearly understood. And with that, Leola, we'll go over back to you for any questions that may come up.
Okay. Thank you so much. And we have questions in the Q&A, and I will go ahead and read those, and whoever feels more comfortable answering, please feel free to do so. We have a question. One of the participants has a roofing business. Companies hire them or hire that business as a subcontractor, and then they hire 1099 workers, contractors, to complete the job. They're asking, how will I classify the workers? So companies hire me as a subcontractor, then I hire 1099 workers.
Let's assume
How will I classify the workers?
Let's assume that the roofing company that's actually got the contract from the general contractor is the person who's asking the question. So he is the employer. For the moment, let us assume that he has incorporated. He is ABC Roofing Company. And ABC Roofing Company now goes out and hires individual contractors, subcontractors. And this is where the distinction that Denny was making, it comes in really critically. If those individuals that they hire to go up on the roofs and pound in the shingles or whatever they're doing, are individual, they're Joe Smith and Bob Green, they're individual independent contractors, and they don't work for anyone else other than the ABC Roofing Company. They may be considered employees, but I want to turn to Denny to get his thoughts on this. Denny?
Joanne, thank you for the question. I think Barry did hit it, is that you own the roofing company and you referred to yourself as a subcontractor. So I think that assumption is fair, that you are incorporated, and therefore you yourself as your roofing company is not where the question lies. You're asking the question on those workers that you hire. And, you know, we want to get you to ask the right questions. We can't answer those workers 1099 independent contractors, or are they W-2 employees? But the right questions to ask get back to that economic reality. For instance, if the situation was all of your workers that you currently are issuing 1099s to are economically dependent on your roofing company, they basically work for you, and they work year round. If you're in a geographic where you can work year round, they're working year round for you, very little work for anyone else. You're telling them which jobs they're going to work on. You tell them the time frames that they will be working. That is the situation where the Department of Labor would take the position that, as Barry indicated, that those are probably employees and not 1099 independent contractors.
And what that means for the ABC roofing company, just to repeat it, is that for every worker that is reclassified as an employee, you have to take the taxes out and pay for half of them yourself. And that's going to be a substantial issue. I'm sure if you're a roofing contractor, you have your own accounting firm. Again, don't depend on just this presentation. Please contact your accountant for their advice as well. Leola?
Excellent. Next question. If I hire a subcontractor to do a consulting project while she is fully employed, would the relationship be of an employee? This is a source of side income for her.
You know, Barry, one of the things that this question relates to, and we failed to bring this up, is if you are hiring somebody to do something in your business, but what they're performing is not the core function of what your business does, how your business makes revenue, that is very much most likely going to be an independent contractor relationship. So for instance, let's go back to Joanne's roofing company. If she hired somebody to come in and do an IT project because she wanted new technology within her roofing company, that's not what Joanne does. Joanne does roofing. So hiring somebody to come in to help her with technology, that's clearly an independent contractor relationship. Never will that be an employee relationship under that example. So with that said, in the question that's being asked, I believe the Department of Labor would look at that and say, no, that's not an employee relationship. As Barry went through, that project probably has a time frame on it, and more than likely, it's not directly related to how the business makes their income, where their revenue source is from. So I think under that question, the regulation would lead you to believe that would remain an independent contractor relationship.
Excellent. Thank you. This next question, we did talk about this a little bit, I think, after the question was typed, but definitely can't hurt to go over it again. We have an independent contractor that has their own business, but we are their only clients. Is the potential for them to have other clients a factor? Potential being in parentheses.
Yeah. So the independent contractor has their own business. That presumes that they have some kind of corporation. But what the question implies is that they're doing work for only one contractor, for one client. By the Department of Labor regulations, as we're just talking about, unless that individual or that the independent contractor could demonstrate that they were doing work for more than one client, there was a possibility that they would be classified as an employee. It's not very pleasant to think about that as an aspect, but my understanding of the regulations is that could possibly happen. Denny, do you have any thoughts on that issue?
I would agree with your statement. I think that definitely would be the Department of Labor's view.
Okay, great. Denny, when you cut out, I don't know if you had to call in or dial back in, but anyway, you were having a great example It says, can Denny finish Florida sales tax example for businesses renting space to an independent contractor? For example, massage therapists, salons, and then it froze, and then I messed with the slides and we got a little messed up. But if you could go back into that, that would be appreciated.
Again, I apologize for losing internet connection. Not specifically on this topic. I was using that as an example, but for the person asking the question, in the state of Florida, let's take a hair salon or a massage therapist company where you're bringing in independent contractors today, and they're using a chair, for instance, in the hair salon, or they're using a therapy room for the massage therapist. The state of Florida looks at that you are leasing space to them, you're renting space, and therefore that's subject to sales tax in the state of Florida. State of Florida has been very aggressive on going after this sales tax. I was using that as an example to how potentially then it could lead towards, are these really independent contractors you have, or are they really employees that you have?
Okay. All right, great. Thank you so much. I was just clicking through a couple other ones there. Okay, so Joanne, I believe, was the roofing company, and she has another question. She did say that the slide explained it a little bit better, and then she said, I am incorporated. Does that mean that the new law may not affect me?
Well,
Again,
she has to be more specific.
Yeah, let's assume though that the relationship that Joanne is referring to is the client hiring her roofing company. And if her roofing company is incorporated, this law does not address that relationship whatsoever. This law addresses the relationship that the roofing company would have with their workers that they are engaging to do the roofing work.
So, but if Joanne is the owner of the ABC Roofing Company, the question originally, as I thought, was she hires independent contractors. But if those independent contractors work only for her, she defines when they work and how much they work and et cetera. The regulations could classify those individuals as employees and not as independent contractors.
That's correct.
Right, and then somebody just messaged me that I can allow Joanne to talk. So we can definitely do that. And Joanne, if you're still on here, why don't you hang on till the end? I'll try to get through a few more questions, and then I think I do know how to do that. I can allow you to talk and maybe ask Denny or Barry something else. Let's see. And it says, Denny, can you explain why you wouldn't be interested in that company if they had independent contractors?
Yeah, and I'll just change the question a little bit. That was an example of where I was not interested. And so in that example, it was because I believe that a value of an organization is many times, not always, many times dependent on the ability to bring the entire company to a buyer. The entire company includes the clients of that company, whatever those clients are. It includes all the intellectual property, perhaps the physical assets of the company, but it also includes the labor force. That's the value that a seller is bringing to a buyer. And if, as a buyer, I'm not confident you can bring that independent contractor labor force with you, in other words, they're just going to go off and work for somebody else, you didn't deliver the labor force. Now, bringing employee base is a little bit more confident that not all, but the employee base will be delivered with that seller for the buyer.
Okay, great. The next is, I have 16 independent contractors. If this moves forward and I have to transfer some of them to employees, can I have both employees and independent contractors?
I think the answer is probably yes, but they have to meet the criteria that we've been talking about. I mean, if they all essentially do exactly the same thing, they'll either all be classified as employees or independent contractors. But if they're doing different things, if the scope of the work is different, Some may work specific hours. Some may have less involvement in the overall nature of the business. They're not necessarily integral to the business. Those people could be classified as independent contractors, where the workers have a job, they go to work every day, they're getting paid, and they're involved in the daily operation of the business. They may be categorized as employees. But the answer to the question is yes, you could have both, but it's the criteria that we've been discussing that'll drive the decision one way or the other.
And just to touch upon that question just a little bit more, this particular question pertains to the participant owns a massage facility with 16 independent contractors. What if some want to remain independent contractors and some employees? Can I do that, or is it one or the other? And you may have already answered that. I was busy reading, sorry.
I don't know what Denny has to think about that, but the way the question's worded is it's not what the independent contractor wants. It's what the employer needs to do to classify the worker appropriately under these new regulations. If I'm the employer or if I own the massage place and I'm renting out space, I would explain these regulations in general to the people. I would explain what the criteria are and see what they have to say about that. But it's really the employer's responsibility, to make sure that they're classifying their workers appropriately, even though a particular worker wants to be categorized as an independent contractor. The facts of the nature, all these things, the totality of the circumstances may suggest they're an employee.
The only thing I would add to that, Barry, is I think out of a lot of these questions, if you're trying to have both employees and independent contractors, along with everything that Barry had just indicated, just realize you're more than likely under a higher risk, because it's unlikely that you can have both employees and independent contractors unless they met those factors that Barry described. It's difficult. And as Barry indicates, it's not what the independent contractor wants. It's what the employer is legally obligated to do.
Yeah, I'd like to take just a moment, Leo, and explain a little bit more about the status of these regulations. I've sat in 3 separate legal webinars on this subject before today. And a common theme that ran through those is that there's going to be substantial pushback on these regulations. The message I heard was there is a lot of vagueness to these regulations. They're sometimes counter to other regulations depending on other laws that are out there. So while it's important that the registrants here understand what the regulations say today and talk with their accounting firms about them, we don't know whether or not there's going to be changes in the regulations down the road. Another set of government regulations called the Corporate Transparency Act has already been challenged in court, and there have been some changes to that. So we're not sure yet, but there's a possibility that these Department of Labor regulations may be challenged as well.
Okay, non-competes seem to lean towards an employee even more under the new rules than before. Do you think non-competes give too strong of an indication for an employment relationship now?
Maybe I could just address that.
All right. Sure.
Because non-compete generally has 2 pieces to it. It has both the you cannot work for someone else portion of the non-compete. And then it has a non-solicitation, meaning you can't take our clients or you can't take our other employees or workers. I think as it relates to unable to work for others within a geographic area, or just simply you're not able to work for others within that industry, I would agree with the person asking the question that that seems to lean more towards an employee argument. If it's just a non-solicitation of clients and employees, I don't think that necessarily leans it towards an employee relationship.
All right. Thank you. I have somebody that is a therapist and owns their own agency that is an LLC, and I have an independent contractor relationship with the main agency that refers clients to my company. I am actively trying to hire therapists that my company will pay. I want the hirees to be independent contractors as well. They will make their own schedules. Do you think they can remain as contractors? They will have other sources of income, not just with my company.
I think those are a couple of really key factors there. If they have other sources of income, if they can come and go as they please, and there is not a lot of control exerted, that would suggest, that's all that I would say, it would suggest that they are independent contractors. But you know, if they're basically, if the individual who asked the question has a building where there are individual offices where the therapists go to provide services to their clients, and again, it's not integral to the overall business, my thought would be that they would be characterized as an independent contractor. Denny, what do you think?
The way the question reads, I would agree with you, Barry. But you know, we're here again to get you to ask the right questions, not answer them necessarily. But I would say, you know, you have to look and say, are those independent contractors, are they economically dependent on your therapist agency, the company that you run? You have to look at that question as well. But I would say the way it's asked, it would lean you're correct, towards the independent contractor.
But if those therapists are marketing their services on their own, they have their own referral sources, which are one of the other criteria that would suggest the independent contractor status. But again, as Denny said, we're basically here to provide you the information so that you can ask the right questions.
Might be the same answer for this question, but once an employer does this analysis of a worker and they are really in the middle of the analysis, how do you think the Florida Department of Labor is going to respond?
Well, it's not the Florida. Would you?
Or maybe federal, sorry, it just said F. Sorry, it says FDOL, so I read into that.
Well, they say they're in the middle. I'm not sure that I could respond. I don't know what they mean.
I'm thinking, you know, possibly.
If I could guess, well, let's put this into perspective where I said the Department of Labor is not going to come knock on your door. That's highly unlikely, you know, unless you've been turned in for some reason. So if the question is, you know, March 11th has come and gone, the law is in place, do you have time to adjust to this and do your analysis and try to adjust to what you think is the right thing under the law? I believe the answer to that is yes, you have time to do that. But like anything, it's the law. The sooner you comply with it, the better off you are. But if you're in the middle of that now and you're going to take the next 30, 60, 90 days, meet with your professionals, make those decisions, I don't think you're under a high degree of risk today.
Okay, great, thank you. I had a couple of things in chat I just wanted to touch upon, and then I'll go back to Joanne. What we were talking about, I think of this might be a fellow or former chat question, but it says very interesting at IBM. Then when we bring on developers to work on a 6-month project exclusively, 40-hour work week, how are they going to be employees? I think that's what it says.
So there's a specific duration that's implied in the question.
6-month project exclusively, 40-hour week employees, 40-hour work weeks. Are they going to be employees?
I would say, well, one of the factors is duration, so it would not meet the duration factor. It would have a definite endpoint. But the other factors, again, we're talking about the totality of all these factors, is what those individual workers, are they integral to the business? Are they creating code that without their work, there is no end product, there is no software? Well, if the answer is it's integral, that would lead more toward a worker. They're controlling the number of hours implied in the question. That would also suggest a worker status. Again, I'm not here to answer the question definitively, but again, you have to consider all of those factors individually. But you're not alone. I mean, there's so many businesses out there that do the same thing. They have a need for a particular type of skill. They don't have that skill in their workforce, and they want to go outside of their workforce. So if they do that, the opportunity to consider them classified as a independent contractor is there, but there's too much vagueness in the situation that it was described for me to figure out one way or the other. Denny, you have thoughts on this one?
I think it's the question that the whole gig community is going to be dealing with. I mean, what that scenario just described is going to affect millions of workers in the United States, because that's what they do. And will they fall under this employee status? So it is a great question. It'll be very interesting to see how truly employers throughout the US address that. And to your point, does the DOL modify some of this based upon pushback?
All right. Do you know if the government will be transitioning all of this in 2024, or is there going to be a grace period?
I didn't read anything about the grace period. I remember that it's effective March 11th. So, this, in a practical sense, this becomes effective whenever the employer is ready to submit their federal taxes, right? So if you're a quarterly payer and you're ready to do your second quarter 2024 taxes, you have the 90 days that Denny was referring to. If you don't submit quarterly taxes and do them annually, you have until the end of the calendar year. But I'm with Denny. I think you need to get started now, not considered urgent, but get it clarified so you can move ahead. You don't want to have this hanging over your head.
Next tax season, I agree. What about special education consulting business with a tutoring network as one component? The tutors would be educators, and this would not be their main source of income. The company itself supports schools through a professional career development. The tutors would teach virtually throughout the US. These aspects would more than likely classify as an independent contractor with freedom to accept tutoring sessions or not.
Yes. I think that's right. But
okay.
I mean, the key there was that they have, they're providing them some tools, but these individual educators come equipped with what's between their ears. I mean, that's their intellectual property. That and you said they're working for other people. That would suggest a classification as an independent contractor, possibly.
Okay, and Joanne, I have clicked on that you are able to talk. I have never done this before, so go ahead and see if that actually let you.
Do you hear? Do you hear me?
Yes, yep, loud and clear.
Great. First of all, thank you so very much for allowing me to ask these questions. I have so many questions after listening to this entire webinar. So I'm going to start off by saying I am incorporated. I am a member of LLC. So several different clients. And when we have clients, I hire independent contractors to complete the roofing job that we have. So for example, I just got a client that needs a roof to be done, and I hired independent contractors to do that job. And that job would only, but then I just got another call that I have another client who wants me to complete the job as well. Now I need to hire other independent contractors. So they're not all the same independent contractors every time doing the job. They're different people doing the job. So this is where I'm a little concerned of where do I stand with this law?
So
Did you hear?
Barry, maybe I'll jump in on this.
Sure, go ahead.
Joanne, the situation that you'd really have to depend on, I think, out of this total economic issue that Barry describes, is look at it from this independent contractor that you're hiring's perspective. If they are working for you short term, specified period, meaning they're just doing that one roofing job that you described, they may or may not work on the next job that you have. And it's not the same crew that you're hiring all the time. That's a strong argument that they're independent contractors. However, if you're having a situation where that entire group of independent contractors that you work with, be that on a job or not a job, they are economically dependent on you. Doesn't mean they work on every one of your jobs, but they're economically dependent on your company. That would argue an employee relationship. So if you could argue the first, that no, they work for other roofing companies, they're not independent, they're not economically dependent on me, that's a strong argument for independent contractors.
And that the work is episodic. They do a job, they go, they're done. They
Right,
may or may not be hired on the next job,
right.
which suggests that it could be implied they're independent contractors, but I again suggest that you talk with your accountant to confirm that. You don't want to be in a position where any of these individuals come back and claim that they're an employee and you didn't pay
Absolutely.
their taxes.
Absolutely. Yeah, and I think in my situation, because we travel, we'll travel to Florida, we'll do jobs in New York, we'll do jobs in Texas. So we're all around, we're all over. So I said, I think this may not, I will be contacting my accountant as soon as this call is done.
Excellent. All right, thank you, Joanne. I have another question. Is it possible for you to repeat the defining difference between an S Corp and an LLC when determining if it's an independent contract versus employee?
Yeah, just a minute. Denny, is this a slide you want to talk to?
Sure. Let me redefine the question because the premise of the question might be a little bit confusing. First of all, when you have a corporation is an entity that's been registered with a state, and that is either going to be a C Corp, an LLC. An S Corp is not a legal entity. An S Corp is a tax election. So it is either what you initially formed as a C corporation or you formed as an LLC, and then you elected S Corp status for tax purposes. So S Corp really has nothing to do with this new law. The issue that I was describing is if you have a legally formed entity within a state, and let's assume that it's an LLC, then that is a subcontractor by our definition, and then that subcontractor is not applicable to this new law. Only independent contractors, individuals, would be.
Did that answer the question, Leo?
I believe so. Thank you. Good clarification there. Oh, well, follow up. So if somebody is contracted, same person asking this question. So if somebody is contracted with you and they are an S Corp, how does that work?
Well, once again, being an S Corp doesn't mean anything. That's a tax election. So what the question really should be, if I'm going to assume that Judith in this case is the individual who was contracted by a company to do the work. So then, Judith, you have to determine, are you an employee or are you an independent contractor with this corporation? If it's the reverse in your question and you're contracting with the corporation, they're legally formed, you have a contractual relationship with them, then this law does not apply to that relationship.
Excellent. I did have a comment from somebody in the SCORE Education Committee that we did have a webinar yesterday on different business types. And then we can look on a link for that website. If I can find that information before we finish up, we will post it on here. So that will be made available if that would potentially help. Let's see.
Great.
And then Joanne just said, I am registered with the state. So I'm just not positive if that was just a comment in addition or if that pertained to an answer on that. But it looks like we have got through everything in about an hour and a half, your perfect time frame. So that was timed perfectly. I'd like to thank everybody for attending our video presentation today. Just once again, you will receive a copy of the slides and this video presentation in your email in just a day or two, so you can refer back to that. And we also will send you a survey that you can let us know how we did today, what we can do to improve, and what other topics that may interest you, so we can bring you another webinar in the near future. So thank you once again, and everybody have a great noon, and great seeing both of you gentlemen today.
See you later. Thank you.
Thanks.
Bye-bye.
Bye-bye.